Okay, here we go. So for our next session, I'd like to welcome Paul Mahoney of the University of Virginia Law School, who is going to get us underway on our Young Legal Scholars paper presentations. These are papers that are selected through a paper competition and written by faculty, by people who have been on the tenure track for for 10 years or less, and also don't need to be on the tenure track at all. So we have 5 terrific papers that we're going to be hearing about. Paul, I turn it over to you.
Thank you very much, Lee, and thank all of you for being here for this Young Scholars panel. I think you're going to enjoy it. We have, as Lee said, 5 really great papers, and I think they will generate some nice conversation. I will very briefly introduce our panelists in the order in which they will present. We start with Ilan Wurman, who is an associate professor of law at the Sandra Day O'Connor College of Law at Arizona State University, where he teaches administrative and constitutional law. Then Jacob Schuman, who is an assistant professor of law at Penn State Law School and is also an affiliated faculty member of Penn State's Criminal Justice Research Center and its consortium to combat substance abuse. Mark Kubisch is an assistant professor of legal research and writing and the director of the appellate advocacy and legal research and writing programs at Pepperdine University's Caruso School of Law. Caleb Griffin is an assistant professor of law at the University of Arkansas Law School, where he teaches business organizations, corporate governance, M&A, and contracts. And finally, Marah Stith McLeod is an associate professor of law at Notre Dame Law School, where she teaches criminal law, criminal adjudication, and plea bargaining. Commenting on all 5 papers will be Richard Epstein, the Laurence Tisch Professor of Law and Director of the Classical Liberal Institute at New York University School of Law. His teaching and research area is law, all of it. The way we are going to proceed is Ilan and Jake will start us off. They will present their papers 10 minutes each. Richard will then spend 16 minutes, no more, no less, commenting on those papers. We will then hear from our other 3 panelists who will also present for 10 minutes apiece. Richard will comment for 24 minutes on those papers. And after after the first session, we'll do 10 minutes of Q&A, which I will moderate, and then 15 minutes for the second portion. My only role here is to keep us on time, and I will discharge that ruthlessly. So when you have 2 minutes to go in your presentation, I will do this. When you are out of time, I will do this. And if you go over by more than 30 seconds, I will switch off your microphone. So Ilan, take it away.
Well, thank you so much. Before my time starts, let me just say that I'm going to have to leave halfway through, which is why I was put first. So my apologies to the rest of the panelists, but I will listen to them on the recording. Okay, so thank you for having me. My paper is provocatively titled Reversing Incorporation. It is about the original meaning of the 14th Amendment, and specifically whether it was intended to incorporate the Bill of Rights against the states. Really, it's a long footnote to my book, The Second Founding, An Introduction to the 14th Amendment. In the book, I argue that the Privileges or Immunities Clause was, at a minimum, the amendment's equality guarantee. We know that the amendment was intended to constitutionalize the Civil Rights Act of 1866, which required equality in contract and property rights and the like. And we also know that the Equal Protection Clause doesn't do the trick, because protection of the laws was a narrow legal concept about legal remedies and protection against private violence and private invasion of private rights. So that leaves only the Privileges or Immunities Clause to do the necessary work of constitutionalizing the Civil Rights Act. And what's more, the language, in fact, does that work the framers in the 39th Congress routinely referred to contract rights, property rights, and the like as among the privileges and immunities of citizens of the United States. These are the rights that all free governments had to secure. That did not mean, however, that the states regulated these rights in the same way. So each state could have a different law of contract or property, but contract and property rights were still rights of national citizenship. A state abridges such rights only if it regulates them one way for one class of citizens and different for another, such as the freed people. Still, the word abridge could easily mean to reduce from a baseline, so it's possible that the clause is both an equality guarantee and a fundamental rights guarantee. Although my book argued for the equality reading, it did not totally discount the fundamental rights reading or the incorporation reading, but it expressed skepticism. This paper finally does the heavy lifting. It sifts through all the leading scholarship and concludes that the conventional wisdom about incorporation is seriously overstated and probably even wrong. So what I found is that there is this pervasive, what I think is a conceptual error in the literature. Most incorporationist scholars conflate any reference to the rights in the Bill of Rights with the Bill of Rights itself. In other words, anytime the right to bear arms or the freedom of speech or the freedom of the press is mentioned in Congress or among the abolitionists, it is taken as evidence that the speaker wanted to nationalize these rights or to make the First or Second Amendments applicable against the states. This is a serious error. As I hope to show with a few examples, it was widely understood that these rights were antecedent to the first 8 amendments. Merely identifying such rights in the amendments as fundamental does not tell us anything about how various other constitutional provisions secure them. The first 8 amendments secure them in their way, but Article 4's Comity Clause, the Republican Guarantee Clause, and the Privileges or Immunities Clause also secure them, but not necessarily in the same way. Okay, here are 4 quick examples of the conflation in the literature. First, both Michael Kent Curtis and Akilah Marr, for example, cite a pamphlet from Senator Plumer written in response to a committee report by John C. Calhoun that had argued that the northern states were obligated to suppress abolitionist literature. Curtis and Marr claim, and I quote, "The pamphlet asserted that First Amendment rights of speech and press were protected against both federal and state interference," end quote. The strong implication is that Plumer believed the First Amendment already bound the states, he was a buried contrarian, or that it ought to. But if you read the pamphlet, Plumer goes through every single state constitution then existing and quotes that state's First Amendment equivalent. He therefore concludes from these provisions that neither the United States nor any state may abridge the freedom of speech, not because the Bill of Rights applied or should apply, but because the states already protected this right under their own constitutions. Second, it was routinely declared that no state may rightfully deny or abridge the freedom of speech or of the press or the right to bear arms. But if you read the statements, these speakers were saying that no state may rightfully abridge these rights because no free government could do so as a matter of first principles. That is very different from saying that the Second Amendment's specific terms apply to the states. And yet almost every time such a proposition is stated in the historical materials, scholars suggest that it militates in favor of incorporation. I think it does no such thing. Third, scholars have relied heavily on statements made by Republicans during the debates over readmissions. To pick on Michael Kent Curtis again, I mean, he was sort of the leader in this in the 1980s. He argues, for example, that members didn't want states readmitted, until they respected the First, Second, Fourth, and Fifth Amendments. That's a paraphrase of Curtis. But this has nothing to do with incorporation. These speakers all relied on the Republican Guarantee Clause. They argued that Southern states didn't have Republican governments, and that the Constitution itself described what a Republican government looks like, including by its rights guarantees. Until the states protected these rights, as a matter of state law, they said, they weren't Republican in form and therefore shouldn't be admitted. This tells us nothing about incorporation. My 4th example is the most provocative, the speech of Senator Jacob Howard when he introduced the amendment in the Senate. This speech is universally believed to be evidence for incorporation. Even Charles Fairman thought that this speech was the strongest evidence against him. But I'm not so sure. It is widely believed that Howard described the first 8 amendments as being among the privileges and immunities of citizens of the United States. What he actually says, though, is that the privileges and immunities of U.S. citizens are the same as the privileges and immunities of Article 4's Comity Clause. What are these? Well, he describes Article 4's Comity Clause rights as property and contract rights from Corfield v. Coryell. And then he says, to these privileges and immunities should be added the personal rights guaranteed and secured by the first 8 amendments of the Constitution. Not the first 8 amendments, but the antecedent rights that the first 8 amendments happen to refer to and to secure in their own way. Howard was using the first 8 amendments as illustrations of what the privileges and immunities of U.S. citizens are, namely the fundamental rights that all free governments had to secure, like freedom of speech and the right to bear arms. He did not at this point say anything about how the clause would secure them. All he says on this score is more or less that the great object of Section 1 is to restrain the power of the states and compel them at all times to respect these fundamental guarantees. Howard's statement can certainly be interpreted to mean that he thought the clause would apply all 8 amendments against the states, but that reading is not compelled. The Privileges or Immunities Clause could ensure this respect either by prohibiting discrimination in these natural and personal rights against a disfavored class of citizens, just like Article 4 does, or by prohibiting any infringement outright as the first 8 amendments do. Either is possible. Let me illustrate that second possibility, or I should say the first possibility. Here's how an 1871 treatise treated Article 4's Comity Clause. The treatise writer, John King, explained that the privileges and immunities covered by Article 4 were the privileges and immunities of citizens of the United States, including the rights, quote, specified and enumerated in the federal Constitution. But the clause itself, he said, only required a state to treat out-of-state citizens equally with respect to such rights. The states without Article 4, he wrote, by their local legislation might and perhaps would otherwise impose different restrictions on the residents of each other, militating against those unalienable rights. Another illustration, and I'm nearing the end, is the way Lyman Trumbull defended the Civil Rights Act, which again was an equality guarantee. Quote, each state, so that it does not abridge the great fundamental rights belonging under the Constitution to all citizens, may grant or withhold such civil rights as it pleases. All that is required is that in this respect its laws shall be impartial. Here are 2 beautiful illustrations that merely identifying the privileges and immunities of citizenship, identifying these antecedent natural rights, doesn't tell us how any particular provision secures them. Fundamental rights can be guaranteed by guaranteeing equality in their provision. In other words, and to summarize, it was perfectly consistent to believe that there were fundamental rights that all free governments had to secure, including the kinds of rights secured by the first 8 amendments, that the states could nevertheless regulate those rights in different ways, but that the federal government could step in if and when the states discriminated in the provision of these fundamental rights, or in Trumbull's words, if the states abridged these rights. That's also the word they use in the Privileges or Immunities Clause. So let me conclude by supposing that I'm wrong, and that the clause is an absolute guarantee of some kind. Even if that's true, that would still look nothing like incorporation. The privileges and immunities of citizens are those rights that all free governments had to secure. The Reconstruction generation said that over and over and over again. So perhaps a state can't prohibit political speech or suppress newspapers, but does that mean no state can prohibit flag burning, the sale of violent video games to minors, Animal Crush videos, protesting at a dead soldier's funeral, stealing valor? The Supreme Court has applied a uniform answer to these questions in all 50 states through incorporation of the First Amendment. But must all free governments have the same answers to such questions? That question, I think, answers itself. Thank you.
Ron, thank you very much.
No temporal trespass.
Oh, yes.
Jacob,
Well to my time.
All right, thank you very much. So my article is called Revocation at the Founding, and it's about how the original understanding of the jury right at the time the Constitution was ratified would apply to revocation of community supervision today. I conclude that the right probably would apply to revocation of supervised release, perhaps not to revocation of probation or parole. So community supervision is a major part of the American criminal justice system. There's currently 4 million people serving terms of community supervision, which comes in 3 forms: probation, parole, and supervised release. These forms of supervision are different in important ways, which I'll get to later, but they all share 4 key features. First, they're all terms of conditional liberty in the community. Second, they're all imposed as part of the punishment for a crime. Third, they all provide surveillance and reporting on the defendant's behavior. And fourth, violations of their conditions are all punishable by imprisonment, which is also called revocation of supervision. Every year in the United States, about 150,000 people have their supervision revoked and are sent to prison, which accounts for about 40% of all prison admissions. In the 1970s, the Supreme Court held that there was no right to a jury trial when the government revoked probation or parole because these weren't criminal prosecutions within the meaning of the Sixth Amendment. But in 2019's United States v. Haymond, the court split 4-1-4 on whether the jury right applied to revocation of supervised release, and the justices focused on the original understanding of the jury right. Justice Gorsuch wrote a 4-vote plurality opinion, joined by Ginsburg, Sotomayor, and Kagan, arguing that the jury right was understood at the founding as a fundamental limit on the judge's power to punish, and therefore the same limit must apply to revocation of supervised release today. Justice Alito wrote a 4-vote dissent, joined by Roberts, Thomas, and Kavanaugh, criticizing the plurality for not showing that courts in the founding era actually used juries in anything that looked like modern revocation proceedings. He proposed that the best historic analog was something called forfeiture of a recognizance, which he said did not use a jury. Finally, Justice Breyer wrote a brief solo concurrence, joining the plurality on the outcome of the case, but saying that he agreed with most of the dissent. Ultimately, I think Justice Alito's analysis is the most convincing, but he's only 2/3 right. He's right to criticize the plurality for not looking at actual founding era practices. And he's also right that forfeiting a recognizance was the closest analog to revoking supervised release. But he's wrong when he says that juries were not required in recognizance forfeitures. Instead, my article presents substantial evidence that when the Constitution was ratified, forfeiting a recognizance did require a jury trial. And this evidence strongly suggests that the original understanding of the jury right would also apply to revocation of supervised release today. So the recognizance was a common law legal device in wide use during the founding era, through which courts could order a party, called the recognizer, to promise on the record to comply with a list of conditions or else forfeit a sum of money. If the recognizer violated a condition, then the government could sue them to forfeit the promised sum. And if the recognizer failed to pay the promised sum, which was typical, the court could order them imprisoned until they complied. The recognizance shared all 4 of the features that define modern community supervision. First, it was a term of conditional liberty in the community. Second, it was often imposed as part of the punishment for a crime. Third, it provided surveillance and reporting on the recognizer's behavior. And finally, violations were effectively punishable by imprisonment. Given these similarities, I argue that the best way to determine if the original understanding of the jury right would apply to revocation of community supervision is to ask whether the common law at the founding required a jury trial to forfeit a recognizance. My article shows that the answer to that question is yes. When the Constitution was ratified, recognizance forfeitures required a jury trial. Records from England, Pennsylvania, Virginia, and New York all show courts using juries in recognizance forfeitures. And legal treatises from the time confirm that juries were required to forfeit a recognizance. I present a lot of examples in the article. I'll just share my 2 favorites now. First, I found an English record of a recognizance forfeiture from 1492, where the King's Counsel realized at the end of trial that, quote, the jurors intended to give their verdict against the king, and so asked the judge to dismiss the case. The judge agreed, but said that, quote, this would be taken as strongly against the king, and the recognizer could never be vexed afterward without a new trial. Second, I found the 1798 case of Commonwealth v. Cobbett, where the state of Pennsylvania filed suit to forfeit the recognizance of a British printer for publishing libels, and he sought to remove the case to federal court via diversity jurisdiction. Ultimately, the Pennsylvania Supreme Court refused his request, holding that the first Judiciary Act could not have been intended to allow foreign recognizers to remove forfeiture proceedings to federal court, where they would, quote, be tried by a jury who know neither the persons nor characters of the witnesses and consequently are unqualified to try to their credit. So what happened to the forfeiture jury? Well, it disappeared in the 1820s with the emergence of a new form of community supervision called laying a case on file. Judges at this time started giving sympathetic defendants a second chance at freedom by taking recognizance while delaying their sentencing hearing. If the defendant complied with the conditions of the recognizance, then the judge would dismiss the criminal charges. But if they violated a condition, then the judge would reconvene the sentencing hearing and impose punishment. courts concluded that judges could reconvene the delayed sentencing hearings in case of violations without a jury, because they were simply resuming a punishment that had been voluntarily postponed. And eventually, laying a case on file replaced the traditional recognizance, and the jury requirement was lost. So this history of the forfeiture jury illustrates a key distinction in how the original understanding of the jury right would apply to revocation proceedings today, between community supervision imposed as an additional penalty versus community supervision imposed as a delayed punishment. In the founding era, taking a recognizance was considered a penalty, and therefore forfeiting a recognizance was viewed as a deprivation of property or liberty that required a jury trial. By contrast, laying a case on file was not considered a penalty, but rather a delay of punishment, contingent on the defendant's good behavior, and therefore punishing violations did not require a jury. This distinction between supervision imposed as a penalty versus a delay helps to resolve one of the key disputes in Haymond. Justice Gorsuch argued in his plurality opinion that the jury right should apply to revocation of supervised release even if it didn't apply to revocation of probation or parole because of a structural difference between these forms of supervision. Supervised release is a term of community supervision imposed to follow full service of a prison sentence, whereas probation and parole are both terms of community supervision imposed instead of imprisonment. Justice Alito, by contrast, said that this distinction was purely formal. Probation, parole, and supervised release, he said, were all functionally indistinguishable, and therefore the jury right shouldn't apply to any of them. Ultimately, I believe the law of revocation at the founding supports Justice Gorsuch's distinction between revoking supervised release and revoking probation and parole. Supervised release is like the recognizance because it is imposed as a penalty. Whereas probation and parole are more like laying a case on file because they both withhold punishment that the government could legally have imposed. Therefore, the original understanding of the jury right would apply to revocation of supervised release, even if not to revocation of probation and parole. Finally, if the original understanding of the jury right would apply to revocation of supervised release, then where in the Constitution would this right be located? I see three possibilities. First, the right to a revocation jury could be part of the Sixth Amendment right to a jury in all criminal prosecutions. Although recognizance forfeitures were formally considered civil matters at the founding, courts also treated them as criminal for legal purposes, even describing them as, quote, prosecutions and punishments. Second, even if revocations are not criminal prosecutions, then the right to a revocation jury could still be protected by Article 3, Section 2 of the Constitution, which requires a jury in the trial of all federal crimes. Finally, the right to a revocation jury is so old and so well established that it could be part of the Fifth and 14th Amendment due process clauses as a principle so rooted in the traditions and conscience of our people as to be ranked as fundamental. Thank you very much.
Richard, the floor is yours.
Floor is mine. Well, I'm sitting here in shell shock, mainly because I think we've been privy to an incredible amount of information in a very short period of time. These topics are really quite different in terms of their sort of general social ambience. I think it's fair to say that when we are talking about Jacob's topic, he's got a local monopoly on the issue, because I'm not aware of anybody at any time who's ever looked at this issue with this kind of depth. I'm afraid that our good friend Ilan is in a deeply competitive industry, because the number of people who have spoken about the Privileges and Immunities Clause from the beginning of time is not quite half the population of the United States, but it is very different. So my disagreements are mainly with Ilan, and I'll try to explain why. I have very few disagreements with respect to Jacob, but I'm going to give it a slightly different view. What's the common theme that I'm going to engage in? Well, I mean, there is a kind of a originalism today, which is not the sort of originalism that I have generally practiced. I should tell you that I am very reluctant to do original archival research, because it's not in my capacity to take notes. So what I have tended to do in thinking about these particular stuff is to look very closely at the textual provision that's written, try to wring as much out of it as I possibly can, in order, I think, to reduce the amount of evidence that you have to spend on collateral sources. I do not regard this as only a sign of my personal laziness. I also think that it's a sign of a sensible way of trying to deal with constitutional construction. If one were to think back to the law of contract and how it is organized, what we discover is there's the same kind of history. Do we believe in textualism and to the exclusion of parole evidence, which would be the kind of legal history we were talking about, or do we want to let all of this stuff in order to explain the way in which things work? And it's very clear that there's a kind of an interesting contrast between the scholars on the one hand and contractual practices on the other. The scholars come forward and they're always willing to say the more the merrier, and they love the thought that they could comb through various bits and pieces of history and come up with an interpretation of this particular contractual provision. The actual people who draft these contracts find this as bad as a cold shower in the middle of winter because their attitude is, I'm going to have to be doing this trial on the ex post basis, and to the extent that you have many moving pieces involved, two things happen. One is there's going to be a greater uncertainty with respect to the interpretation, and two, it's going to be more costly to get to the situation. So this kind of pushes you, if you want to think of this as a statutory as well as a contractual issue, closer to the Scalia position, in which you have an acute allergy with respect to legislative history for exactly the same kinds of reasons. So I started to think that you want to look at these as textual things. The question is, what can you get out of this? Well, starting with Ilan's paper, I think his basic instincts are right and wrong at the same time. I think he's clearly right to say that if you're trying to look at the privileges and immunities clauses drafted, it would be very strange to say that it incorporated the first 8 amendments of the Bill of Rights, because for amongst other things, if you wanted to incorporate the first 8 amendments of the Bill of Rights, you could have written a provision which says the first 8 amendments of the Bill of Rights are hereby applied against all of the states and be done with it. They didn't do that. Well, what did they do? They talked about privileges and immunities, and this is a takeoff from Article 4. The question, though, is to how do you characterize them? Ilan was quite correct to say at the outset that somehow or other you've got to be able to tie this thing to the Civil Rights Act of 1866 and the question of what does it do. And you look at it, and what it kind of does, it says, oh, you have the right to enter into contract, same as white people. You have the right to sort of make wills, and a whole variety of civil capacity provisions that essentially have been denied to anybody who had been a slave, and so forth. Now, the real tension in this is one that he mentioned, and which we did not quite resolve. The Civil Rights Act of 1866 was a provision which saw the same as white people. And so what you can do is kind of read in that a sensible extension of Article 4, where you're talking about discrimination against. On the other hand, as he noticed and didn't kind of like to deal with, if you read the text of the provision, it doesn't refer to discrimination at all. It says, no state shall make or enforce any law abridging the civil rights, the privileges and immunities of the citizens of the United States. And so there is already a very deep kind of contradiction between the legislative history as it relates to the 1866 bill and the obvious transformation and contrast with respect to the language. But there's another element in here which I think has to be brought into place, and this is as follows. Ilan, when he gave his particular presentation, what he did is he announced that you can't use the Equal Protection Clause to get equality values, and he's right for at least one of the reasons. He says equal protection actually took the protection part as powerfully as it did the equal part, and it clearly meant that when you had criminal prosecutions, you could not chase after somebody because of his race. And it turns out that you could not, when it came to protecting other people, decide to give strong protection for crimes against white people and no protection against crimes against black people and all the rest of that. But then the question is, so you've got to get equality, and how do you get it out of the Privileges and Immunities Clause? And that's the part which is not so clear in the way in which it was stated. And here's the way I think in which you sort of have to look at it. The most widely ignored portion of the text of the 14th Amendment is that the first clause is the citizenship clause, and essentially it reverses Dred Scott and says everybody's a citizen. Well, the next question you have to ask, well, what's the payoff for being a citizen? And if you look at the next 3 clauses, it's only the Privileges and Immunities Clause that applies to citizenship. It does not apply especially to anybody who is dealing with either due process or equal protection. Well, at this particular point, the way to look at this is a matter of kind of equal international law and so forth, because you're trying to figure out who are the persons who are not citizens, and the most obvious candidate are people who are aliens. And it turns out that when you start dealing with aliens, and there's a kind of a strong international practice on that, aliens come into the country at sufferance, and so there are two things that we tend to withhold from that, which are related to the 1866 Amendment. The first of these things is occupational freedom. You do not get that as a matter of right when you come into the United States. You have to supplicate in all sorts of ways in order to do it. And similarly, you do not have the right to own property except a sort of short-term rental of one kind or another. Because again, you're only an alien. We tend to give all of these rights, but oftentimes we give them subject to recognizance type arrangements, right? See, Jacobs, you're still relevant. In which they can be revoked at one way or another and expelled and so forth. Whereas for citizens, these rights are sort of absolutely powerful. So what happens is you're trying to figure out how it is that you read the 1866 Amendment into the Privileges and Immunities Clause. It's the citizenship word that does the thing, and that's the thing that starts to talk about all the stuff about civil capacities, because the things that citizens have that are indefeasible include the right to own property, and therefore the right to make contracts, and the right to give wills and so forth, and the right to enter into various kinds of occupational freedom. So it's a pretty strong guarantee. What happens constitutionally, of course, is a complete and total nightmare. We have an endless amount of history, and the way in which I think the verdict runs is as follows. And I rely here on an old but very good book by my NYU colleague Bill Nelson, which is if you count the number of quotations which treat privileges and immunities as a non-discrimination provision, there are probably more that do it that way than treat it as a substantive protection. But if you look at the text, it runs in exactly the opposite direction. So you have this constant question as to which way you want to go. I tend to be more of a textualist and would treat them as the fundamental right side. But what happens is if you then talk about the slaughterhouse case, the most decisive feature of the case is it's not that it resolves this dispute one way or another. What it does is it simply truncates the entire structure of the entire clause when it says the only things that are protected are your rights as citizens of the United States, i.e. the right to use interstate rivers and the right to petition the government. So why did they do that? Because their attitude was under either of the two views, Justice Miller said, we got the central government being a perpetual censor on everything that the state can do, to which the correct answer is that was the whole point of this particular kind of arrangement. We really did want to have that kind of veto power over it, and we wanted it to be enforced certainly by legislation and also by the judiciary when it's there. So I think he's right to say that it's not going to be done by incorporation of the Bill of Rights. But I do disagree on this. I don't think there was a wild set of subjectivity and disagreements, the kind of thing you give in your first paragraph. I'm a Roman lawyer by training, and what happens is if you look there, the early tradition had a very different view of the subject than the one that you took. It took the nature of the substantive right as being pretty much taken for granted and pretty uniform across all these things, the right to make a contract, the right to own and to make property, the key ones being, of course, there. But what it said is you're going to get a lot of different local variations on the formalities that are associated with and attached to the way in which these things were put into place. And so the difference would be I enforce a contract by theft, you enforce it by the statute of frauds, I use a registration system, you use a town crier and all the rest of that. And the difference that Gaius refers to is one which actually tracks its way through the entire history of Western civilization. So I tend to think that it's a little bit better, and I think it makes more comfort for your position, Ilan, because if you do have a kind of a core of substantive rights that are there, then you avoid the difficulty of saying every state is going to have its own ability to define what the rights are. What you say is that the states have their own ability to figure out the formalities associated with respect to their protection, which is a very different thing. Now, going on to Jacob's paper, again, I look at all this stuff and my eyes start to glaze over. I do come to the conclusion here that I think actually he's right about everything that he has said in the end. I'm very uncomfortable about that. I like to be able to say that people have made some fundamental conceptual error of one sort or another. But the way in which I look at this sort of thing is, again, really quite different from him. And it is the thing, I tend to think of this as the following question. If somebody is sitting there out there as a stranger with respect to the world, there is going to be some kind of necessary protection in the criminal law which says that you cannot deprive this person of his natural liberty, even for the commission of a crime, unless there's some kind of a hearing or trial that is going to be given from them. And this is, again, something which does not come out of the recognizance case of 1742 and so forth. You go back and you start looking at the original kind of criminals courses and so forth, and you do my Roman law approach, right? Because you don't mention this stuff. But nemo iudex in causa sua. Nobody's allowed to be a judge in his own cause. Audi alterum partem. Always start to hear the other side before you do this. What's going on in all of this stuff is there is a necessary notion that the deprivation of liberty is such a powerful constraint that there are going to have to be procedural safeguards that are going to be put into place. And these find their homes in the presentment and the grand jury. They find their protection on the civil side with juries, and they find them with respect to due process. Now, with the question of liberty, the kind of nifty sort of question that you start to face is the easy case, is the one where you have somebody who's a perfectly free person, and then what you do is you throw them into the clink, and you're going from 0 to 1 or 1 to 0, and it's perfectly clear that the protection has to apply. The situation that Jacob describes, I think with a great deal of accuracy, is we are not talking about the beginning to the end. We're talking about interim states that start to work. And so when you start to shrink the amount of things, what we do is we have a baseline which is not total freedom. And in some cases, therefore, we end up back in prison, but you started some very different places. And so the question that you might want to ask is, are various kinds of partial deprivations of liberty right to be regarded as something to which we give constitutional convention? And there are other cases that have done this, which you didn't mention, but that seem to me to be always of interest. Suppose it turns out that you have somebody in jail and they sort of misbehave, and what you decide to do is to throw them into solitary confinement. Well, using the analysis that you have done, the question is, would you require there be some kind of a jury determination in order to deal with that issue, given the nature of the major deprivation that's going to be imposed? And the answer to that is twofold. The first answer is yes, because what we look at the size of the deprivation, and when we understand that, we realize this is too big for us to ignore. And then the second answer is no. And the reason we do the second answer is, in the normal case of liberty, when it's deprived, we don't have to worry about the way in which the administrative state applied before the punishment was imposed. But the moment you start hearing somebody being put into jail under these kinds of circumstances, you start to think, well, were they set up in some serious way by the administrative body? Or if we have large numbers of people who are subject to this, are we going to have to superintend every single change of status inside the prison one way or another? And we tend to revoke that. And so what Jacob is saying, I think, is really rather clever. I think we should talk about these things by way of a comparison. But I've got a relatively clean situation out there, and if in fact what you do is you remove somebody from their relative freedom and you revoke their privileges to do something, if it turns out, and I think he's right about this, that what's happened is they've already served a basic sentence and you're extending it a little bit further, that looks a little bit more like a deprivation of liberty than the situation where essentially you could keep them in jail, and what you do is you give them a kind of action by grace to go a little bit further. So it's not as though you can find this thing etched in all of the particular documents, but this is, I think, the way in which you want to think about what Jacob has said, which is you're doing constitutional law, you're doing institutional arrangements, and that the most fundamental insight that you have under all of these cases is you're always worried about which form of imperfection turns out to be the greater imposition when you're under circumstances where you can't get everything right. And so if you draw a distinction like this, the argument is not that you can find counterexamples, which you always can, but the argument is if you kind of take the paradigmatic case and the way they go, does this seem to make sense? And I guess having heard of all that he said and having read the paper, I've come to the conclusion that he's correct, and I don't wish to overstate my time, so I won't say anything more.
Thank you. Okay, so we are going to give the audience 10 minutes now to offer any questions that you might have. While you make your way to the microphone, I'll just toss out a question for Ilan. Of course, I don't do con law constitutional history, so this may have a simple answer that I don't know. But it seems to me that in the late 18th century, it would have made a lot of sense that almost everyone would have said there's a pre-political right to speak, to assemble, and so on, and there's a positive implementation of that right in the First Amendment, but the First Amendment did not create the right. But I just wonder if by the late 19th century, under the influence of Bentham and Austin, we can really say that maybe, I think some academics at the time would have said the freedom of speech is the First Amendment, period, full stop, and I just wonder if some legislators might have thought the same.
Yeah. All very good questions, so going in order that I received them, just Richard's point. I also am a textualist. I don't think there's a much difference between text and intent, as most people do, but that's why I think there are only two plausible meanings of the 14th Amendment, right? Abridge could mean reduced from a baseline, or it could mean equality, by the way. It doesn't define itself. Lyman Trumbull used it, equality. Section 2 of the 14th Amendment, when it talks about the right of a state, or if a state denies or in any way abridges the right of any male over 21 years to vote, again shows, John Harrison has made this point, that the word abridge can be used in an anti-discrimination way. And so either the clause is a fundamental rights guarantee with respect to all rights, which gets us not only incorporation, but also potentially Lochner, okay? Or it's an equality guarantee only with respect to all these rights, or it does both with respect to all these rights. But there's no picking and choosing, incorporation for the First 8 Amendments, but no Lochner, merely anti-discrimination with respect to common law rights. So I agree that the text narrows that down. Between the equality and absolute components, though, only the history can tell us which of those they meant, and that's why I rely on the history. As for the citizenship clause, your point is well taken that it could probably do the work, but it's a historical matter. It just wasn't what they thought was doing the work because it was added at the very last minute. The citizenship clause was not in the draft, was not in the final draft. It was added at the very last minute in the Senate.
Was added?
The citizenship clause.
Yeah.
And so they certainly did not think that that was doing the equality work. They thought that privileges or immunities clause was, and then someone said, oh, hey, but again, if you still think Dred Scott was right, no one has overturned that officially, we should still define citizenship. And so they added it. Does that make it redundant? Maybe, but as Randy Barnett once said, and I love saying this, redundancy is good in airplanes and it's good in constitutions. And he, by the way, I don't think thinks it's redundant in this case, but I would live with that. Paul, the short answer to your question is they were all steeped in the natural rights tradition. As far as I was, reading through the 39th Congress, the abolitionists. I have not seen anything like the Benthamite or a positivist view of these rights, just as a historical matter.
By the way, I agree with that.
Thank you.
Yeah.
Bob?
Hi, Bob Cottrell, George Washington Law School. For Ilan, I've got so many things sort of wrapped around what you're doing that it's hard to sort of disentangle them. But I wonder, indeed, if that difficulty in disentangling may be the key to understanding the 14th Amendment and privileges or immunities. One of the things that's obviously animating them is Dred Scott and overturning Dred Scott, but part of it is this idea that citizenship brings with it certain rights, a part that even Tawney outlines in Dred Scott, and which I think the people who draft the 14th Amendment, rather, are in agreement with, that there's not a fundamental conflict there. But another part about the 14th Amendment was the members of Congress who enacted it actually saw themselves as the primary enforcers of the 14th Amendment, not necessarily the courts, which they were still suspicious of from both Dred Scott and indeed with Bingham, Barron itself. So I'm wondering if one way to the extent we can do some disentangling, might be to look what Congress does on what it thinks the 13th and 14th Amendment had empowered them to do. And I wonder if we need to move beyond the Civil Rights Act of 1866 and perhaps look at the Freedmen's Bureau Act. Among other things, the Freedmen's Bureau Act intends to protect the right to bear arms. And again, once again, there's a difficulty in disentangling equality and rights of citizens. But I think that's a part of what we need to look at in terms of trying to figure out, okay, what is it these people thought that they had essentially empowered themselves to do? And I wonder if the Freedmen's Bureau Act is one way of looking at that.
Yeah. All terrific points. Just very, very quickly, I agree with you about citizenship and Tani, and goes back to Richard's point, which, yes, citizenship implied equality, which makes me think that they're potentially redundant. And Randy Burnett's here again, so I could talk about the redundancy point, which I love. So thank you, Randy, for saying that. It always stuck with me. So that's all well taken. On the Freedmen's Bureau, what I'll say is, at least Trumbull and others, they defended it under the war powers, and so that's a bit different. I think I'd have to look more into that, but that's how they initially defended it. And in terms of the enforcement power, right, they thought the 13th Amendment empowered them to enforce equality in the rights of citizenships within a state. As Trumbull said, he was talking about the power of Congress to enforce the 13th Amendment through the Civil Rights Act of 1866. He said they can give and take civil rights as they please, so that they don't abridge the fundamental rights of citizens, that the laws must be impartial. And so I think that's what it empowered them to do, was to guarantee equal treatment in these fundamental rights. At least I think that's how Trumbull did it. But all your points are well taken and deserve much more extended response.
Thank you. Tyler Lindley at BYU. I have questions for both of you. It might be easier for me just to say them both, and then you guys can answer them. Jacob, I wondered, I'm not an expert in criminal law, and I wondered, in response to this, if the court adopts this view of this dichotomy between, not dichotomy, but the distinction between supervised release and parole and probation, how easy, given the functional descriptors of these, it would be for states and federal governments to switch over most of their enforcement mechanisms to parole and probation to avoid these types of jury trials. Obviously, they couldn't just change the name, because you did a good job of identifying distinctive features, but how easy in practice would it be just for states to kind of avoid the jury implication by changing what they're doing? And then for Ilan, I wondered, as you were describing the difference between even assuming a fundamental rights basis between how the court has interpreted the first 8 amendments for the federal government and how they would do so for the states. If your problem is more how they've interpreted the first 8 amendments for the federal government, and with a better deferential approach to how Congress regulates those rights, it would actually look a lot alike.
Yes.
Okay, great, thank you.
Yeah, 1 minute each.
Sure. So, I mean, it would be as easy as passing a statute, which can be easy or hard depending on the makeup of Congress. Supervised release was created in 1984 in the Sentencing Reform Act of 1984, so we did it once. We could do it again, and I think, from my personal perspective, it would be a beneficial development if states and the federal government said, we don't want to deal with juries and revocation proceedings, so we're going to go back to parole. And that's how we'll impose supervision, and it'll be exchanged for a shorter prison sentence. I think that'd be a good thing. In theory, judges, when they sentence defendants, could say, I'm shortening your prison sentence, and I'm giving you supervised release instead, and that would functionally be the same kind of as exchanging supervision for imprisonment. I don't know what that would mean for my constitutional theory, but on a case-by-case basis, judges could do it too.
And just a quick response, yes. If the Supreme Court hadn't interpreted these rights in a certain way, or if they interpret it in a more narrow way that I think is consistent with originalist history, the difference between my view, an absolute rights reading, the narrow one that I put forward, all free governments, and what the first state amendments actually do would collapse almost entirely, but not entirely, right? I mean, my state of Arizona, where I teach, has a First Amendment that says liable to abuse of, such speech. So you can, I don't know, that sounds to me as though the Sedition Act might be more constitutional in Arizona than, under the federal First Amendment. So, and in terms of the Second Amendment, mission militia, so there could easily be variation in the states, nevertheless. And so it still would do work in that context, I think.
Well, let's all give a round of applause to Mark, the floor is yours.
Thank you. My paper, the thesis of my paper is that requiring state employees to contribute to state public pension funds violates the First Amendment by compelling association with the pension fund and by compelling subsidization of the public pension fund's speech. I think that's especially true with the rapid rise of environmental, social, and governance factors, or ESG. And I have 3 quick points that I want to make today. The first is to look at the Janus decision and how that would apply to the public pension context. The second is I think there are potential broader implications of that application than have previously been discussed, because the application of Janus might not just be to prospective contributions, that is future contributions to the public pension funds, but to the current contributions in the fund themselves at present. And then finally, I think that if we apply First Amendment compelled speech doctrine to public pension funds, that theory might also apply to the current movement towards auto-enrollment of individuals into 401k or 403b plans. The Secures 2.0 Act just passed, and that's imposed a requirement. But first to Janus. In Janus, which was in 2018, the Supreme Court struck down an Illinois law that required individuals to contribute, whether or not they were a member of that union, to the dues to a union in order to cover the collective bargaining costs that the union incurred in its collective bargaining between it and the state. And in reaching this determination, the Supreme Court overruled a longstanding precedent of Abood. Abood held previously that you could compel individuals to pay union dues because limited to kind of the costs associated with that union representation. But here in Janus, the Supreme Court held that it's ultimately a First Amendment violation subject to exacting scrutiny to require an individual to have to contribute to subsidize the speech of another. And this was true even though the union had a duty to provide fair representation to all members, and even though one of the rationales was for kind of the payment of this agency fee was if it wasn't to take place, there would be free rider problems. People would be able to benefit from the union representation. So the court held that was a First Amendment violation under the compelled speech doctrine, and in doing so, in describing Abood, it further noted the impossible nature of distinguishing between chargeable and non-chargeable expenses. So how does that relate to the public pension context? And here I'll use CalPERS as an example of why I think CalPERS, required contributions to CalPERS is a violation. So CalPERS, if you are a member of the California state government, you're required to contribute, most of you, required to contribute to CalPERS. And then CalPERS takes those funds, and it has almost half a $1 trillion, and it has stated guiding investing principles where it will engage with a variety of corporations, especially now with the dramatic rise of ESG, on particular points. And so what we've seen at present in CalPERS is it has engagement, both private engagement, but also public letters it will write to those corporations, arguing that, for instance, climate change or board diversity norms need to be implemented. And in fact, it boasts on its own website, it's engaged with over 800 companies, and 584 of those have implemented changes based on those engagements. But it's not just that private engagement, although that engagement is dependent on the right. You're going to listen to CalPERS because they have $500 billion, right? If you're a manager at a corporation, you want to pay heed. But the other reason is there's proxy voting, especially as ESG has arisen. We've seen a deluge of ESG-related proposals, including over most recently 200 relating to climate change, for instance, and carbon emissions. And so what we see from CalPERS is kind of voting on those particular issues. And the only way CalPERS is able to do that is because of the funds contributed by the individuals who are contributing to CalPERS for their retirement. So that's the basic theory about why I think it's a compelled speech violation. There are two likely objections I could see. The first is that, well, these are investments driven by long-term value considerations, and so this is just purely economic decisions. There's evidence on both sides empirically that ESG might kind of benefit investments and the like, and so therefore it's justified. I think the response to that can be found in Janus itself, where the Supreme Court expressly says we don't want to engage in that type of line drawing. And I think there, as another scholar has noted, the only difference between ESG value investing and ESG values investing is based on an individual's intent. It's incredibly hard to figure out, are you making these investments because of long-term value, you think it promotes long-term value, or because you want to achieve a particular goal. And in fact, a lot of the arguments deployed by certain individuals in support of ESG is that this is a way to address social issues outside of kind of the political process that's incapable of addressing it. The second issue I see that could be raised is that of government speech. So CalPERS is a government agency. Why wouldn't it be able to? Why can't it do this? 2 points. The first is in the 1990s, the Supreme Court issued a decision in Keller, where it basically, even though the California State Bar was a government agency, the Supreme Court held that for purposes of First Amendment analysis, it was not, due to the lack of control by the state government and the function that the State Bar served. I think a similar argument might be raised, and others have raised it, with regard to CalPERS, and that members of CalPERS are elected. Several of them are elected, as well as CalPERS has discretion in terms of investments. The second reason, though, that I think the government speech doctrine would be a poor fit here is because of the property interest that individuals who contribute to retirement funds still have. And the reason for that is in several states, including in California, the doctrine now is you enter into an implied in fact contract, unilateral implied in fact contract with the state when you begin working at the state. And so in CalPERS, or in California, for instance, if you leave the state of California, you are paid back you can receive back your contributions. And so my argument is that it would be a very strange doctrine to say it's government speech. I don't know of any of the other government speech cases that require that kind of touch on an area where you still have some form of property interest in kind of what you're paying into a system. The other 2 points I want to quickly touch on are, second, I think these consequences are broader than have currently been anticipated. In most of the analysis so far has been focused on future contributions. So adjustment of, these are deducted from paychecks, considerations of, well, let's just, instead of paying it to the employer who then contributes it in, we'll just contribute it directly and the like. But I think that has its own issues, but I think the larger issue is that continued property interest in some form. In the union context, the agency fees cases, there wasn't, courts, it was unsuccessful to recover payments that had made in prior years because that connection between those contributions and the individual had been severed. Here, however, because of that residual interest, and the continued use of those contributions for proxy voting, I think there could be an ongoing violation. And then finally, for auto-enrollment, under Janus, there's a requirement that you affirmatively consent to any speech or to the union, and I think a similar argument can be made with regard to auto-enrollment into these ESG funds that have increasingly arisen. So that's my point, and thank you very much.
Very good. Caleb.
All right, I think I have some slides. There we go. Perfect. Thank you.
You have slides?
Yes, visual aids.
Oh, no. I can't turn my head.
So I'll begin by discussing the contrast between the classic view of stock pricing and the pricing for most other markets. The market for most goods and services is generally said to have a downward sloping demand curve, which you can see here, excuse me. So for instance, if the price of a good or service increases, the quantity demanded decreases. So maybe a good example would be airline tickets. If the price of airline travel increases, some consumers might switch to driving. Some consumers might fly less frequently. And others, though, will have more inelastic demand. They will still fly the exact same amount at the higher price. So for most normal goods, as the price increases, it causes some, but not all, consumers to change their behavior. In contrast, the stock market is considered to be somewhat special, and unlike most other markets. Instead of a downward sloping demand curve, the stock market is said to exhibit this horizontal demand curve. And the idea is that stock price is set at a certain fundamental value. This value reflects all information about the stock, and there's really no reason for anyone to pay more than this fundamental value. Corporate law has very much adopted this classic view, and I provided a quote here that illustrates this view from the legendary Frank Easterbrook. It says, "There is no economic market in Jefferson's savings stock," the stock at issue in the case, "as there is in dill pickles or fluffy towels." He's a funny guy. Investors do not want Jefferson's savings stock as if they sought to paper their walls with the beautiful certificates. They want monetary returns at given risk levels, returns that are available from many financial instruments. There are so many substitutes for any one firm's stock that the effective demand curve is horizontal. It may shift up or down with new information, but it is not sloped like the demand curve for physical products. So that is the dominant orthodox view, which has received widespread adoption throughout corporate and securities law. We have assumed that even if there is significant demand for a particular stock, it won't affect the price because the demand curve is horizontal. However, there are an increasing number of what are referred to as anomalies, situations that don't fit well within the traditional paradigm, and so here are a few of them. First, the classic anomaly is the index premium. This refers to the notion that index inclusion or deletion generates abnormal returns of some kind. So, for instance, being number 501 on S&P's famous list is quite different from being number 500. Arguably, this shouldn't happen. Adding something to a list doesn't make it make more money or change its fundamentals. And yet we do see a stock price boost for additions. Now, this anomaly has been debated since the 80s, and alone, perhaps it could be explained away. So it wasn't by itself enough to seriously challenge the classic theory. But in the past few years, a number of other anomalies have emerged. The first of these new anomalies is multiplier effects. Multiplier effects refer to the impact that a single dollar invested has on equity values. So under the classic view, there is no multiplier at all. It's zero. However, recent studies have identified multiplier effects at the macro, the whole stock market, factor level, and the micro or individual firm level. So for instance, on average, each additional dollar invested in a given stock increases equity values, not by $0, as the classic view would predict, but by a little over $1. Next, meme stocks are another recent anomaly. If we buy into the classic model, demand from a small group of investors shouldn't have such a significant impact on prices since it does not change the firm's fundamentals, but demand did in fact drive up a number of prices during the meme stock episode. And it's in a way that you can measure also as a multiplier. So one study put GameStop's multiplier at about 5.5, which means that during that meme stock phase, about every dollar invested in GameStop generated a price increase of $5.50. Classically, again, that should be zero. So meme stocks are a third anomaly. Next, recent research suggests that the historical outperformance of ESG, not this year, but over about the last decade, ESG has outperformed, that it is actually flow-driven, that it is driven by increased demand. And ESG stocks would have underperformed the broader market without that increased demand. This again can be illustrated as a multiplier. So the multiplier is estimated to be between 1.2 and 1.7, so higher than the overall average firm multiplier, just the standard stock of 1, but lower, significantly lower than that for meme stocks. Additionally, there's some recent research on the effects of stock buybacks. So the classic view is that stock buybacks arguably should not impact stock prices since they don't convey any new fundamental information. But in reality, there is an observable stock price boost for stocks that experience a buyback. It also happens for connected firms, and it also happens for the broader equity market. None of those should happen under the classic framework. And then finally, the last anomaly I'll talk about is investor inducements. We've seen the proliferation of what are called inducements or perks for shareholders rather than consumers. So perhaps discounts on products or free items for investors. One semi-famous example is AMC, the movie theater chain, gives free popcorn to if you're a shareholder. And so if you own some shares, you're an investor, wow, I get some free popcorn too. Should that affect the price of the stock? And the answer is no. It should not. If we're talking about fundamentals alone, they should have no impact whatsoever on stock price. However, the evidence suggests that these perks are associated with both a short and long-term share price increase that's quite durable. So ultimately, I argue that based on a significant amount of new evidence, we have ample reason to believe that the classic theory doesn't fully capture what's happening in our markets today. So I propose that rather than viewing these things as random, disconnected anomalies, we should recognize that they're driven by a single shared factor, which is the influence of demand on equity prices. I argue that stock has three potential sources of value. The first two fit within the classic view, and I'm proposing a third. We have the control premium, the value that comes from possessing control or governance rights. We have intrinsic or fundamental value, and the new one, extrinsic or non-fundamental value, the boost that comes from demand. And collectively, I refer to these as the value triad. So, does this new theory imply that stocks have a downward sloping demand curve just like most other goods and services? Yes and no. I argue instead that stocks are characterized by asymmetric demand curves. And by this I mean that intrinsic value, the fundamental value, acts as a kind of floor for stock prices in most cases, but demand can generate significant increases above this intrinsic value baseline. Why? Well, I go into a number of causes in the paper, but probably the most significant factor is the market for corporate control. So when prices rise, value investors, like a classic investor who acts like the orthodox theory predicts, they can't do much to bring prices back down. They can sell their stock, they can even short the stock, but they can't really influence what other people are doing. Now, in contrast, if a stock is sufficiently undervalued, it's too cheap, they can influence what other people are doing when they offer a significant premium and when they acquire the firm. So this means that potential acquirers can effectively cause the price of an undervalued firm to increase and set a floor, but they can't cause the price to decrease and set a ceiling in the same manner. And so we observe this asymmetry. In the paper, I also argue that stocks exist on an elasticity spectrum. So although the average multiplier is 1, as we saw earlier, extrinsic value is not uniform across stocks, as individual stocks and individual investors exhibit different elasticities. I provided here a sort of stylized elasticity spectrum comparing various types of stock. Stock range from meme stocks, sort of the high end, very inelastic, to boring stocks, which I've called them on the left, which are sort of less exciting and have lower multipliers, and they behave more like sort of the classic orthodox stock. So revising our theory in this way has a number of important implications, a few of which I'll introduce briefly here. First, if demand can influence stock prices, then that means demand could be a novel avenue for generating shareholder wealth. If demand is an independent channel that influences share price, that's something that firm managers and shareholders would likely care about. Relatedly, directors might in some contexts have a duty to at least consider the effect of demand on share price. And even if you're a director or an audience member who's somewhat skeptical about extrinsic value, there are a number of examples of companies essentially leveraging extrinsic value into fundamental value by doing things like issuing additional equity. Third, regulators should consider demand when regulating things like buybacks or ESG labeling, including the names rule. For example, research shows that heightened returns for ESG funds are correlated with how the fund is named rather than its actual underlying ESG characteristics. It also informs the debate on buybacks generally, as well as the debate on potentially regulating coinciding purchases and sales by executives. So if buybacks mechanically increase demand, regardless of some sort of informational or fundamental value content, I think that potentially allows for managerial opportunism, and that's in fact exactly what we see. Executives are twice as likely to sell shares after buybacks are announced. More broadly, there are implications for some academic research involving event studies. When we measure how much stock price reacts to whatever event we're studying, we sometimes have assumed that you could ignore things like the magnitude and directionality of flows, but this suggests you can't. As we saw, multipliers exist and they're often very significant. So one of the most important implications of this paper is that it may call into question some of the academic research that relies on event studies. And similarly, in some of our event studies used in securities cases perhaps need re-examination as well, because the outcome depends on our assumptions about demand and the slope of the demand curve. That concludes my presentation. Thank you so much.
Thank you. Amazingly good. On time.
Marah.
Thank you. So a general norm in American law and culture is that people should not be punished more than they deserve. Sentencing scholars describe this idea typically within the framework of limiting or negative retributivism, and they call it the consensus model of punishment in the United States. So under this model, desert does not itself require punishment as it would with positive retributivism, but it permits punishment. Whether punishment is in fact imposed depends on other state concerns, such as the utilitarian goals of deterrence and incapacitation. Now, in practice, desert seems to prove a remarkably weak constraint on punishment. Just recently, for example, the Ninth Circuit declined to invalidate a sentence of 292 years in prison for a series of nonviolent offenses. So my paper is focused on how such sentences can be imposed given our general norm against undeserved punishment, and how we can reform our sentencing procedures to better align those procedures with this substantive norm. And I don't want to dwell on why appellate courts like the Ninth Circuit have upheld sentences like the one just mentioned, which would require a likely answer within convoluted Supreme Court doctrines governing proportionality and habeas procedure, but on why and how a sentence of 292 years for a nonviolent offense, a series of nonviolent offenses could be imposed in the first place. Now, critics of retributivism tend to answer that this kind of sentence is entirely predictable. The concept of desert, many claim, is malleable, inherently amorphous, and arbitrary. It's easy to claim that nearly any sentence is deserved because this notion has no inherent content and is based on subjective values and intuitions, sometimes discriminatory ones. So these critics claim that the notion of desert, rather than operating as a limit on punishment, operates instead as a license for excess. Such critics have proposed a fundamental reorientation of American criminal justice away from the principle of desert and toward constraints focused instead based on utilitarian goals and social justice. Now, I argue that our society should not, and realistically is not about to, give up on desert so easily. Instead, we can and should do far more to align our criminal procedures with our substantive commitment to desert as a limiting principle. Our current processes of sentencing needlessly encourage arbitrariness, distortions, and exaggerations in the assessment of desert. So the first part of my paper explores the role of desert and the corresponding principle or concept of retributive proportionality within our sentencing laws as they now exist. As one would expect, the laws of both states and the federal government frequently embrace desert as a threshold requirement and a constraint on criminal sanctions. But these laws do not ensure that, in practice, sentences will be constrained by reference to desert. They do not require that desert is assessed independently at sentencing. Instead, they permit sentencing judges, and in some states, and in capital cases, sentencing juries, to weigh the incommensurate goals of desert and utility at once, and when these goals conflict, as they sometimes do, to prioritize utility. This unstructured approach to sentencing procedure decimates the power of desert as a limiting principle and invites the kind of sentences as the 292-year prison term I just mentioned. These excesses, however, are not, in my view, the inevitable products of a focus on desert. They are the predictable consequences of the temptations of sentencers to exaggerate or ignore desert when forced simultaneously to consider the competing goals of future public safety as expressed through terms of incapacitation or deterrence. So in this paper, I propose procedural reforms to address these problems. For one thing, sentencers should be required to determine first how much punishment is deserved. And in this first stage, they would consider evidence that bears on the gravity of the defendant's culpability, on the seriousness of his intentions and actions, as well as, on the opposite side of the ledger, the expected severity of the punishment. By contrast, they should not be advised about the future dangerousness of an offender, how likely the offender is to be rehabilitated, or how much punishment would be likely to deter others. Under current law, all this evidence is considered at once, distracting from a clear focus on moral desert. To further encourage a focused and forthright analysis of desert at the outset of sentencing, I argue that sentencing judges, should be required to state on the record how much punishment is deserved before turning to those questions about utility, about future costs and benefits. Moral desert naturally may be difficult to express as a single amount of punishment, so a sentencing court should be permitted to instead define a range of deserved punishment or not undeserved punishment, as limiting retributivists tend to argue. Only after this express determination of how much punishment is deserved should a sentencing court turn to utilitarian goals in order to determine how much deserved punishment would then be useful to impose. This procedural bifurcation will improve the transparency of sentencing determinations and enhance the ability of observers and the general public to question whether these moral determinations properly align with public norms. This last point gets to a second related issue, one that perhaps should be fleshed out in a separate paper, but which for the purposes of this paper that I'm now addressing, they're combined. And this issue is whether judges are in fact properly situated or suited to establish the moral bounds of punishment based on desert. This is not a challenge to the principle of desert, but again to the process by which it is considered. If desert is a moral question without any demonstrably correct answer, then in a democracy, shouldn't this moral assessment be based on the values of the people? Requiring sentencing judges to make their judgments about desert more transparent and on the record will certainly improve the capacity for public reactions and critique, but that may not ensure that moral judgments undergirding sentencing align with public norms. Even if the public takes an interest in such desert determinations, which is a big if, public reactions to judges' desert claims may be ill-informed, as they will be if they're based on sensationalized media accounts simply about the crime. So a better way to align desert determinations with public values and thus to constrain the sentences imposed in the name of the people based on the values of the people themselves would be to ask lay people directly to determine how much punishment is deserved. And so my more radical proposal to implement the principle of desert is that juries, not judges, should decide this question. Jury is an ideal tool for expressing public norms rather than the subjective values of individuals because it depends on discussion and compromise among a large number of lay citizens. These citizens bring fresh perspectives to criminal cases and are less likely than judges to be consumed by legal intricacies or rules and more able to focus on the moral questions. They do not, furthermore, share the institutional incentive of judges and prosecutors toward harsh sentences in tried cases in order to encourage future defendants to plead guilty. This does not mean, in my view, that juries must or should decide all aspects of sentencing. Juries and judges have different spheres of competence. Judges have expertise and an overview across cases, as well as knowledge of costs and institutional constraints. They may be better at predicting future utility and promoting consistency across cases. Thus, judges, not juries, should decide or may be better tasked with the subsequent assignment of determining how much deserved punishment to impose for the sake of future benefits. So I make this jury proposal as part of a broader movement towards a democratization of criminal justice by drawing it closer to the norms of the people that the criminal law is meant to serve. It differs in a few respects from other proposals by other democratization scholars. I will note two of them. So several scholars have argued that trial juries should be informed about sentencing consequences, which they currently are not, on the expectation that such juries will nullify by acquitting against the evidence if the applicable sentence seems too harsh. In my view, this needlessly distorts the law and would not ensure that the jury's decision is based on desert rather than other considerations. I would say that it's better for juries to directly assess desert and limit sentences based upon it. Other scholars have argued that juries should be required to decide all aspects of sentencing. But as noted earlier, juries may not be as good as judges at utilitarian predictions or cross-case comparisons. Furthermore, we may be mistaken in thinking that simply because we have mostly used juries for factual determinations, that is where their best use, in fact, exists. So my view is to employ both juries and judges to the extent of their relative legitimacy and competence. Thank you.
Thank you. And we'll now hear from Richard.
Yeah, thank you so much. I mean, I think this is a case in which Gaul is divided into three parts, two of which are more or less close to one another, and the third, I think, which is a sort of a remote province. So I will take them in the order that is given. And again, I think here my basic sympathies are with all of the authors. There are differences in levels of ambition on this. I think I'm going to give to Marah the prize of trying to solve the most intractable problem in the history of Western civilization in 8 minutes. I think the other papers, Mark's papers and Callum's, are small, so I will take small things first and then turn to large things. On the small things, I mean, one of the things that we have to understand is that the entire institution of collective bargaining, whether done privately or done by the state, has always been an issue of, shall we say, I think of immense constitutional complexity. What Mark does is he starts to go into the story in medias res, where we've already got ourselves labor unions that are put into place. These come in the private sector starting in the 1930s, and they spread very rapidly in the early 1960s to governments when John Kennedy, in January of 1962, in one of his most underheaded acts, decided that he would recognize collective bargaining procedures for public employees, even though Franklin Roosevelt well understood that the mechanism of collective bargaining, which he wanted to put into the private sector, is in fact one which would not work in the public sector, and I think there's a lot of evidence to that effect. The difficulty, of course, with respect to collective bargaining is what we're supposed to do is to worry about a system of freedom of speech under Janus and similar cases, while ignoring the fact that the entire relationship is a coerced contract under a monopolistic form. So the standard procedures in collective bargaining is that there is an employer, at least in the private sector, who is faced by a union. There is an election, the majority wins the election, and the employer has to deal in good faith with a particular union, and God forbid should ever be allowed to enter into any kind of direct relationships with his own employees. To me, this is flat out unconstitutional. I've always believed in the earlier situation. And what happens is I think a lot of other people kind of agree with me, but what happens is they can't seem to do this under the economic side because we have this low rational basis test by which we evaluate these things. So what we do is we try to get half of the apple back by doing it under the freedom of speech side. And in the Abood case to which Mark referred, Justice Potter Stewart, very sensible, kind of middle-of-the-road guy, says, I think I can draw the allocations between union-type events on the one hand and expenses associated with politics on the other. I think, in fact, that you actually can draw that line, but everything depends on who you turns out to be. You means anybody on the face of the globe except the union, which is actually in charge of making these distinctions. And so what Justice Alito essentially thought was that the entire episode was something of a charade, and that there was a massive shifting of political activities into non-political activities in an effort to keep this. And so he said, I can't police the line because I don't trust the agents who were doing it. I think this is right, Mark. And so what I'm going to do is I'm just going to blow the whole system up and say what you have to do is to give these people the right to get out. And what happens is I think this is an extremely kind of sensible sort of decision, but it still is not entirely satisfactory because you may not have a position in which you pay. You then lose some influence, but it's still the case that the collective bargaining agreement, to the extent that it's involved, will require you to live by a set of terms voted by a union in which you have no influence. And so, opting out is not necessarily going to give you freedom. It's going to essentially say that if there are conflicts of interest amongst workers, since you're not paying for the union, you're not going to be the one who's listening to. So your situation is going to be more compromised, which is not an entirely happy situation. It's also, I think, one of the things that happens is in the Supreme Court, what you discover is they believe in grand terms that they will bestow sort of general principles, and then what they do is they march on and talk about something else the next year. So I don't believe there's another Supreme Court case on the Janus problem since that time. But the unions have not been quiet, and what happens is you start to see a series of rules that determine the way in which the opt-out can be done. And these have been called sometimes Hotel California rules. And what one means by a Hotel California rule is that the union is entitled to specify the times, terms, and conditions under which you can actually exercise this right of withdrawal. And if you make it scarce, if you make it hard, have narrow time windows, give insufficient notice, saying if you don't withdraw within the 10-day period and so forth, you're now bound to pay the dues for the next entire year, what you can do is really slow down the effectiveness of this particular provision. All of this stuff is now being litigated in one form or another, but what I think we discover, to our great sorrow and regret, is that one of the difficulties that we have when we have a reasonably conservative Supreme Court and a reasonably liberal federal judiciary is that the federal judiciary down below is quite happy to sort of undercut in various sorts of ways everything that the Supreme Court tried to put into place. So that the way in which this thing has played out under the current situation is that the withdrawal that has taken place have been much less rapid than one might have expected given the level of uneasiness associated with the overall discussion on these kinds of issues. This thing, in effect, therefore, becomes extremely questionable as to what's going on here, and whether or not we should have to have the Supreme Court come back again. I think the answer is we clearly do. There is, for example, when you take anything in the First Amendment, you say, I have a right for freedom of speech and so forth, and a right to go into a public park in order to work, and then somebody comes along and says, you absolutely have a right to work in that public park. You apply 90 days in advance for a permit, you pay us the following kind of fees, you get the following sort of insurance and so forth, you supply us with security guards of one kind or another, you have your right to speech. But we always evaluate the right of the speech as against the appropriate burden that is put upon with respect to its exercise. And when we start to do that, we tend to strike many of these kinds of conditions down. What's happening is we don't see this. Things in the last year or so have become even more complicated because what happens is labor law, at least in the private sector, is heavily regulated by the NLRB, and in the states, what happens is it's California, it's New York, it's Illinois that are doing the regulation on this stuff in the public union, and these are not known particularly as strong employer states. So that what happens is the administrative control of this situation is strongly sympathetic to the unions, which is no surprise, because whenever it turns out that you get public unions, it turns out that unions make enormous contributions to the various members of the legislature, which effectively puts them on both sides of the table and creates the sort of anxiety that we otherwise have to deal with. So I think, in effect, the idea of trying to push this again is correct, The only difficulty I have is not whether he's right as a matter of theory, but whether or not as a matter of practice you could get enough political muscle between what's going on. Now, the second of our papers also deals with this, and it deals with the estimable Frank Easterbrook. And the one thing you could always say about Frank is his greatness, and his much greatness of Frank, lies in his relentless willingness to oversimplify complicated problems so as to come up with some sort of tractable solution. And this is not necessarily a foolish kind of an idea, because what happens is if you start to constantly begin by looking at your flanks and protecting against this, starting with qualifications and so forth, what you never do is you never get any kind of strong position that you can develop, and so you become relatively helpless. And so I think of all the writers on the federal judiciary, he's the most arch, stiff-necked, stubborn, and clear writer that you're ever going to find. Now, what happens with people like that is there are two outcomes. One is their rigidity is reasonably close to a world that you start to observe, and so the inferences that they start to draw are going to be relatively powerful. And the other is it turns out that the model is just completely inappropriate, so that what's happening is going to be utterly irrelevant. And you have to figure out which way it goes. And so here, let me sort of give you what I think is the kind of situation. If you start looking at standard kinds of goods, what you discover is that when people buy or sell these sorts of goods, they often do so with dual motives. So, for example, nothing is more common than today for somebody saying, I will not buy a conflict diamond, or I will not buy something which is not made with union labor and so forth. And they're willing to back their particular preferences in this particular case by deciding, in effect, to pay more money in order to go elsewhere in an effort to try and squeeze things out. And I think there's absolutely nothing wrong with people expressing these kinds of opinions. There is a particular good in question. There's a practice that they wish to target. And one of the things they could do is they could pay higher fees and then give money to a charitable organization that wants to achieve that end. Or they could do it in this particular fashion. I think freedom of choice is perfectly appropriate. So when you're dealing with standard sorts of goods, I think what happens is it's not only that demand curves are sloped downward because there's imperfect substitution, it's also that people do not act of the most narrow conception of their self-interest when they're starting to look at various things. When you then start going into the ESG world, there's a literature, I think Jose Schenkman is associated with this, which starts to say when people are buying and selling stock, they're not these narrow Freemanist type people who only care about the bottom line and do something everywhere else. These are people who always take into account their secondary values when they start to deal with the way in which stocks work. And it's that kind of thing which is getting close to what Caleb is hinting at in the way in which it goes. And I've actually written something about this, and this is the view that I have. Yes, it turns out that people do have secondary views when it comes to the question of what they want their corporations to do. But if you start listening to fancy people at the University of Chicago, you will always assume that the secondary views that they start to take are going to be liberal in their orientation, so that it's a unilateral problem, and therefore it's just absolutely delightful if we decide to invest in a company and say we are thrilled with the fact that they won't sell guns anymore or cigarettes because they think money. But you know, the United States is a larger country than the 10 great universities in major cities. It has all sorts of other people, including lots of people who think that smoking is just fine, lots of people who actually think that owning guns is important in self-defense, that hunting is in private, that the National Rifle Association is involved. So the problem that you get when you start taking into account second values is they're not uniform. They're completely heterogeneous. And so at that particular point, the optimal strategy that you would want to have is to try to make sure that your investors who are running the corporation ignore all the secondary values, simply work on those issues that are common to the beginning, and if they then do that, people can take their own money. But on the other hand, the point that he makes is still valid, which is when you start looking at shares, there is no reason why it is that if you have a company which makes a certain kind of commodity, which is disfavored when it's treated as a commodity, that somehow or other you're not going to see exactly the same kinds of situations develop with the corporate market that you see in the individual market. And so if that kind of behavior is going to start to take place, well then what should we expect to do? we should expect to see that people, in making their individual choices, will in fact stay away from certain kinds of stocks for certain kinds of reasons because they simply don't like it. Now, that's not the only way in which you can start to think out about how you do this. There may be other things that are going on which is sort of simultaneously. So one of the things that Caleb talks about in this particular situation is buyback. And you have this sort of standard model of buyback. All sales are homogeneous. They all work the same thing. And what happens is when you start having a buyback, the people who get the cash out for the shares are no better or worse off than the people who stay in the corporation, because it's exactly the kind of situation you'd want to have. But that's a too simple analysis, I think. And let me tell you what the problem is. Oftentimes, it's an election as to whether you do or do not take the cash offer. Everybody's not bound to do so. And so the people who want to cash out have different preferences than the ones who want to remain in. And so they can satisfy their preferences by taking the cash. On the other hand, if the other people who remain are people who sort of think that the set of prospects that the corporation has are better in some sense than the group that left thinks they are, the prediction that you would make is that the value of the residual shares will go up. Because it turns out that you have a selection of some sub-portion of the particular market which is more inclined to do this. We know, in effect, that the reasons why shares trade in particular markets, because there's somebody out there who thinks differently from somebody else, and you combine private and public information in such a way that the person who has the lower valuation does one thing, and the person who has the higher valuation starts to do the other thing. And by the time that you're done, you come up with a reasonably coherent situation on the way in which you go. And so you can go through all of these variations, and I think he's pretty much right. The interesting thing is I don't think in and of itself this observation tells you that you ought to regulate various kinds of markets. If Frank Easterbrook is mainly right but it's partly wrong, it doesn't matter so long as the trades could go. The real issue is, I think, the fiduciary issue that starts to come. If you're some large company, it's the same problem with Mark, and your CalPERS or somebody like that. The question is, how do you treat your shares? Which way do you start to vote and why? Generally speaking, in my view, if you're a fiduciary, what you should do is ignore all of these collateral consequences and concentrate only on the value type situation. And this again goes right back to the paper that Mark issued, in which what you see is people trying to move heavily in one direction or another, which whenever I think is in general a mistake. So I think in effect that it's a kind of a very useful contribution to understand this. And this is a case where when the complications come out, what it does is it doesn't show you that markets don't work. It doesn't show you that you need regulation. What it shows you is, the world's just a little bit more complicated place, but that market transactions could cut through with it. So now I guess I'm into my last moment. I have to take a deep breath and try to figure out how to deal with Marah's paper, because it deals with a different subject, and she is trying to take on one of the major questions that one sees throughout the entire history of the criminal law. And that's the question in its most general form, is we sort of have two theories of kind of liability or responsibility. One is retribution, and one turns out to be deterrence. If you state the differences between them, they sort of sound kind of dramatic. So if you believe in a retributive theory, what you do is you isolate in on the particular act that a given person has. You start to ignore all of these collateral consequences that may do something. The set of excuses that you have is going to be relatively narrow, so you're never going to allow the poverty of a person to become an excuse for the commission of murder or rape or anything else. But if it turns out that this person is subject to various kinds of duress in the commission of an act, or acts under a fundamental mistake of one kind or another, those are things that are intrinsic to the situation, and so you will start to take them into account. And the criminal law is plenty complicated when you start to do this. Just think of the many variations that we have on murder, with all the stuff having to do with mens rea on the one side, and having to do with the various kinds of defenses like provocation on the other side. And then you get these utilitarians, on the other hand, and they're saying, we do not just treat this guy as an isolated individual. We know that the criminal law is basically designed to deter future actions of given sorts. And this deterrence essentially comes in two orders. They're not mentioned in Marah's paper, but I think they're there. One is specific deterrence, what you're going to do with a particular individual whom you lock up to deter future offenses once they're released. But there's also, you send the rest of the world a message out there, and the hope is that when you punish the one person, other people out there will understand what's going on, and it will reduce the incidence, frequency, and severity of the crimes that are associated with the action. And it seems to me, if you start looking around and saying, okay, which of these theories is legitimate, what you have to do is to come up with the unhappy answer that they both are things that necessarily are going to play a role, and I don't think anything she says it denies that particular issue. But then the question is, well, what is the inherent difficulties associated with punishment? And let me sort of say the following kind of observation. One of the things that this paper doesn't do, and most other people don't do particularly well, is you have to kind of tell me a very clear situation in which the deterrence theory starts to push you in one direction, where the retribution theory starts to push you in another direction. And it seems to me that they can't just be contrived illustrations, they have to be relatively high-frequency events so that you can see why it is the difference is there. So I look to my favorite philosopher, a man with great genius and zero common sense, I mean Immanuel Kant. And when he starts to talk about this, he says that anybody who believes in retribution will punish somebody criminally, even by death, even if he knows the world is coming to an end in an hour afterwards. So it can't possibly make a difference for future deterrence or anything else. And my reaction when I hear illustrations like that is shame on you. We are not living in that kind of a situation, and if we were, so many other things would fall out of whack that the criminal law would be a rather unimportant situation. And so what you have to do is to find more common cases in which you have to undergo this sort of a situation. You better put the time on. And here, this is the fundamental problem that I see. And it's a problem that essentially basically embarrasses both the retributivist theory on the one hand and the deterrence theory on the other. The common element that both of these theories have is that everybody believes that the punishment to some extent ought to be proportionate to the severity of the crime. And as Marah notes, it's often very difficult to figure out exactly how this severity ought to be measured in any particular case. But there is the following problem that exists in the criminal law, which is it is all too easy to give illustrations where if you double the savagery of the crime, you cannot double the savagery of the punishment. And so take an illustration, for example, in which you start to talk about somebody who commits a crime of murder. And let's suppose that you actually believe that they can deserve capital punishment, and that you think that the desert theory, contrary to what she said in her paper, can be used to stiffen up punishment, right, retributivism, rather than to lower it down. You want to do this. Now you get two people. What do? You kill the person twice, obviously. But the second one has no marginal deterrent effect whatsoever. And then what you start to figure out, it also has no operational sense within the retributive world. So the problem about the criminal law is that the level of harm that you can commit is essentially unbounded going up, but at the same time that the level of punishments that you can give is strictly bounded, unless you, even if you believe in, but usually you don't, in various kinds of torture. And so what you then have to do is to recognize that you're never going to be able to get this thing right, whether you're talking about deterrence or talking about retribution, because you have to do one of two things. Either you have to change the spacing so that everything goes below the cap, at which point you don't get the right kinds of increments. You underestimate the difference between two cases, and that's an offense to the retributivist theory, and it's an offense to the deterrence theory. Or what you do is you try to keep a large portion of the domain with the right spacing, and then you get to the top of this thing, and it turns out you've got zero marginal deterrent as you start getting to the end, and zero incremental punishment. So in both of these cases, it turns out that you just cannot get everything right. Well, what do you do in order to try to solve this problem is something quite different. Namely, what you say is, you know what, if I can't get this from the ex post state, what I have to do is to expand the scope of punishment so that I could find different ways to deal with the problem. And what do you do is, well, all of a sudden you start punishing attempts. Now, if you had perfect deterrence and perfect punishment for completed crimes, you wouldn't need the defense of the attempt situation. But since you don't, if you punish attempts, it broadens the number of cases you bring into the system, and therefore allows you to increase the severity of the punishment. And then we go after people for aiding and abetting, for conspiracy, for God knows what other kind of collateral offense, all of which are designed to make sure that we can get different people into the system and sort of pump up both the retribution and the Republican. So the problem that I have with her theory, and I think it's an extremely difficult one, is I don't know how to distinguish the two systems cleanly, given the fact that they both have this particular problem. And I don't understand how it is that you're going to be able to organize this. It's not that I'm against it, in such a way that you're confident that you've got the retributive side first, get that right, then you get the deterrent side second after that, and put it together. If you're before a single judge, the knowledge that I seem to take place is actually by one of your uncles by marriage, Jose Cabranes, right? And Jose hated all of these guidelines of one sense or another, open rebellion against them, because he said, in the end, it's all a big old mess, and I regard my intuitive judgments as better than sentencing guidelines or anything that we have. And so that becomes essentially the basic challenge. I don't think there's any way, through any set of particular procedures, that you could take a judge who has one set of priors and force them to a different kind of conclusion because you have a general theory of such and such. And this is, of course, really terrible because on the one hand, and I'll just end on this note, the thing that we always love is individuation of punishment to take into account the unique features of everybody. And the thing that we hate is treating like cases in a different fashion, and it turns out you can't both individuate and uniformly treat these things. So I regard the criminal law as basically a constant project of an open wound that continues to run. We can make it marginally better or marginally worse, but it's much more important to have the right kind of people running this system rather than trying to get any abstract set of rules that is going to be able to control the issue of punishment and discretion. So I'll end on that.
Thank you. All right. We have just about 15 minutes for discussion, questions, so on.
Ben Johnson, Penn State. So Caleb, I continue to be upset that you...
I can't hear it louder.
Sorry. Caleb, I continue to be upset that you wrote this paper ahead of me.
Sorry.
So it looks good. But so the question I have, so it's been a long time since I took Micro 101, but I remember there were two lines on the graph. So I see the demand curve, but the supply curve is interesting too, right? So implicitly what you have, I think, is a vertical supply curve. You're basically saying there's a fixed amount of stock in the world and it's out there, but that's not true, right? So it turns out, so AMC, for example, now they for a moment they capped that out, and then they created these ape things specifically to try to get more stuff out there. But fundamentally, it's a market where people are out there saying, I would sell my AMC stock for whatever else, right? So in some sense, I think what you're making is a very compelling case that there's actually a market for stocks qua stocks, and these are not just kind of. We always used to think they were financial instruments that traded at the present value of future discounted cash flows, and that's kind of like the magic, we don't have to think about market clearing prices, and you're saying, oh, no, there's a market for this stuff, and I'm like, well, you only showed me half the market, right? So I would just say, I think the demand part is very interesting, and it's worthy of a paper or whatever else, but I just don't think I think you're missing a really important part of the story, and I just think you should do that.
I appreciate that comment. That's really helpful, thank you. Just to respond really quickly, that 1 minute. Yeah, so I think that's great. I think you definitely can issue more share values and more shares, and I think that's one of the ways to capitalize on that extrinsic value. But I think the shares you issue are still affected in the same way. So I was trying to make sort of a narrower point. Even these new shares that you're saying, if you change the supply, if you buy them back, if you create new ones, whatever, demand will affect those shares in this framework that I'm trying to outline. So that is my point. But hopefully the next paper I can get the supply in there too. Thanks. I knew I forgot one line there. There you go.
Hi, Mark Scarberry at Pepperdine Law School. I don't know if this matters, Mark, for your paper, But I think Janus was not about drawing lines and saying, well, this is appropriate to charge and that's not. I think Janus was about saying with public employee unions, everything they do in bargaining is political speech because it involves allocation of public funds. So you can't really divide it out and say, this is organizing and it's okay to charge that, but this is political, it's not okay to charge that. It's not okay to charge anything because it's all political speech. And so you can't charge a non-union member anything if it's a public employee.
Do you agree with that, Mark?
Pardon me?
I'm asking Mark whether he agrees with that. I don't.
I was going to say
Well,
both.
I think that's what the court said.
Yeah, I'm not entirely sure I read Janus that way. I think Janus, the court is saying there's matters of public concern, and I think part of what's animating the court's analysis there is kind of the aggregation effect that these particular determinations can have on society at large. So to me, in the corporate space, that's where I see it is, okay, we've got these seemingly minor decisions, but the culmination of these can have very significant impacts. In fact, that's the appeal of them.
Oh, okay, I mean, that's fine. I don't think that's what Janus says, but the other one with regard to crimes, is it in Sweden, depending on how wealthy you are, that what you have to pay in a fine for driving under the influence goes up the wealthier you are. And so I'm not sure you're more at fault because you're rich and you drive under the influence, but you get penalized more. And I think that's to cause deterrence because people who are rich, if the fine is set, they don't care. And
Well,
so I don't know if
actually,
this...
One of the dangers, of course, you get is it means that certain activities are now going to shift from rich people to poor people in order to reduce the punishment. And so there's a very nice paper from 20-odd years ago by Jennifer Arlen who said that if you're actually worried about the efficient solution, the last thing you want to do is to charge different rates to rich and to poor people because of the substitution effect it would have. And if you really believe that, well, we make everybody equal because when you start to buy goods in the marketplace, what you do is you always prorate the prices so the rich person has to pay more for a loaf of bread or a pound of stuff, and by the time you do all of that stuff, we're egalitarian. So, I mean, I actually think that the Swedish are wrong with respect to that. I thought the paper was very powerful against it. I'm going to say something else about this. I think, in effect, that in principle, if somebody says we've got individual grievances by workers who are being dismissed for alcohol abuse, tardiness, or whatever it is, and you put into a fund stuff for the union to represent that, I don't have any difficulty in starting to say that these kinds of things are, in fact, grievance related, and they're not particularly political because you have the same thing on the private side. I'll even go one step further. If in fact this analysis is correct that it's all political, then you have the same kind of difficulties associated with private unions, and so there's a real question then as to whether or not the state, when it forces you into this system, is compelling speech in one form or another.
Yes.
So the Janus situation should apply to public union, to the private sector unions as also public sector union. And I mean, it's ironic, the American left would think the worst thing you could possibly do is to extend the principles of state actions to employers, or to the government actions over employers and unions, but in effect I think that would apply, and then you would have Janus essentially would apply to all unions, and we could sort of put the whole business to rest, which is what I would have otherwise done. But I don't think that that's the case. I think what the real problem was they thought was, this is a line in principle, but they basically believe that if you started to look at the splits, they're running them 85-15, when the honest evaluation is probably going to be closer to 50-50. They don't think they can police the line, so they say, fie on you in the situation. And then, of course, the lower people, I mean, in lower courts and so forth, they treat public unions in a semi-heroic fashion, right? And so that's where I think the differences start to take, is a fundamental difference as to whether we regard these things as the angel of death or the angel of mercy.
I think, yeah, I'm sure you're right about that. But normally we would say the actual collective bargaining over wages and these sorts of things could be chargeable. But Janus says that can't be chargeable because that involves allocation of public resources, which is political.
Fascinating debate.
Thank you.
Marah, I'd like to give you the opportunity to respond to the wealth
Oh,
question.
thank you. I appreciate that. So you want an example. I'll give a very, very common example, which is people who are mentally handicapped in some sort of way, whose illness makes them dangerous but less culpable. You can't even imagine how much mental illness there is within our prisons. Most of this doesn't even get analyzed within the criminal process because these people are threatened with draconian sanctions. They plead guilty. Their attorneys know, fighting, trying to get evaluated will take time. We may lose this salutary offer, so we're going to take the offer. So an example where there's a clear divergence between the limitations of desert and what would be a lack of limit under deterrence, that's one example. The other is I think there's a problematic tendency to focus on ordinal proportionality without considering absolute proportionality. That is to say, like, this is a worse offense than the other, therefore retribution requires us to punish it more, and not to have that gut check on how much punishment is really appropriate. My view is that America's pretty darn harsh, and my view is also that I think it's too harsh in general, and that the people are not compelled to contemplate the realities of punishment that prison in particular entails here. And so I think that we need that gut check. Too often we have judges saying, okay, this is typical for this offense, we'll impose something a little bit more, a little less, even if they're considering desert. That's just not good enough. So I would say, if forced to say, am I more concerned about the balance between crime and punishment than about whether the gravity of this crime gets a greater punishment than some less significant crime in the past? I would say I'm more concerned about that absolute balance because I think we've got our system out of whack. Another point is I'm taking on not the debate between retributivism and utilitarianism, but what I see to be a common norm, which you acknowledge likely is, which is that desert is a constraint. If we take that seriously, how can we effectuate that? I do think there's an unsettled debate between whether we think retribution is enough. There's no doubt in my mind that an attempt to differentiate a determination of desert from utility will advance the ball in terms of getting compromise and deliberate debate over what to prioritize in terms of those purposes if we separate our analysis to the extent we can, whether judges or juries.
Look, I'm going to say again, I don't think that the traditional retributivist theory treats desert as an upper bound on punishment. So the way this started was an eye for an eye and a tooth for the tooth, right? Meant that your life for a life and so forth. What it was a very rigid system of parity that was imposed with no excuses to be allowed. And it essentially, you could go from the bottom to the top under that particular system. So I think that to try to say that desert somehow acts as a constraint on the severity of punishment, it's using desert in a way that was not used in the traditional theory.
Let me clarify there real quickly. I am not attempting to go back historically to what it was or what theorists have argued. I am attempting to describe what American legal democratic compromise has created within its law, and that, I believe, is either limiting retributivism or simply desert as a constraint. That is essentially the consensus model within our law, like it or not. I sympathize. I think we should
my
go for
view
desert
about it
coupled
is
with-
there's just an enormous variation in the United States, and I think some people would agree with you, but the red and blue distinction that we have everywhere else in the law might apply here.
Gene.
Yeah, I'm curious, Marah. This may be a little bit off of what you're talking about, so but I'm curious of the reaction. This isn't my area, but what I've heard repeatedly from people who work in the area is that most of the crime, certainly most of the violent crime, is committed by a very relatively small number of people, and if you actually get those people
Off the street.
You have reductions of 30 or 40% in the crime rate in major cities. And I'm wondering what you make of that given the structure you've laid out. So let me throw that to you and see what you say.
I think it's fundamentally morally wrong to punish someone more than they deserve. I do think moral desert is a real there's a moral truth about that. And so I agree, I don't dispute the factual basis. I just think that we cannot subordinate that principle in the interest of having a safer society. And I do concede that there may be, there's real harms. I am not willing to have judges making that determination. I think the people themselves who will be facing the risk, including the communities most prone to crime, have to say, desert really matters to us. Currently, the law does make desert matter. And so maybe we should reject that. I'm not going to vote for any law that rejects desert as a limit, but I will cede to the democratic judgment if other people want to. That's not what our law currently does. So I agree, efficacy-wise, maybe that's what we would do. I just think it's inhumane and wrong.
We have reached the end of our allotted time. I think this was a fabulous panel, and I'd like to thank again all of our panelists, and especially Richard for taking on the task of commenting on all these great papers. So thank you all very much.